Jai Hind, Jai Bharat. So today we are up with yet another important topic from the Code of Civil Procedure, that is foreign judgment. So two most important sections that you people are supposed to study while reading foreign judgment is section 13 and 14. However, to proceed with section 13 and 14, it is important to understand the definition of foreign court and foreign judgment, and the relevant provision allotted to the same is mentioned on the screen. So basically, foreign court means a court situated outside India and which is not established or continued by the authority of the central government. So, any court which is situated outside India and has not been established or continued by the authority of the central government is referred to as foreign court under the Code of Civil Procedure. Then, what is foreign judgment? It is as simple as that. It means the judgment of a foreign court is a foreign judgment. So, before moving to section 13 and 14, it becomes necessary to understand the definition of foreign court and foreign judgment. So, let's take a quick recap. Basically, any court that is situated outside India and has not been established or continued by the authority of the central government of India is termed as foreign court, and judgment of such foreign court is known as foreign judgment. So, now coming to section 13, which is the main section of today's lecture. Basically, it embodies the principle of res judicata in foreign judgments. It also embodies the principle of private international law that a judgment delivered by a foreign court of competent jurisdiction can be executed and enforced in India. I repeat that the judgment delivered by a foreign court of competent jurisdiction. So, the court which has delivered the judgment must be having the competency to deliver the judgment. And those judgments, if delivered by the court of competent jurisdiction, they can be executed and enforced in the territory of India. Okay, so moving further, what does section 13 says? So it elaborately provides those situations where the foreign judgment cannot be held to be conclusive. So the title of section 13 is when foreign judgment not conclusive. A foreign judgment shall be conclusive as to any matter thereby directly adjudicated upon between the same parties or between parties under whom they or any of them claim litigating under the same title. So the general rule is the language of the section is starting from an affirmative note. It says that a foreign judgment shall be conclusive. There is no doubt on this fact. However, there are certain conditions, and the conditions are that the matter that which has been adjudicated by that foreign court, it shall be directly adjudicated upon between the same parties. The parties shall be same. There shall be a direct adjudication, okay, or the parties under whom they or any of them claim, they shall be same, and it shall be litigated under the same title. So, if all these conditions are fulfilled, then we can say that a foreign judgment shall be conclusive in nature. However, there are this six exceptions to it. That if our case falls under any of these exceptions, then the foreign judgment cannot be held to be conclusive in nature. So, one by one, we'll discuss all of them. Going by the bare language, the first possibility is when the foreign judgment has not been pronounced by a court of competent jurisdiction. So, obviously, jurisdiction is very important. Jurisdiction essentially means the power or the authority of the court to decide the matter. So, if the court is not competent enough, if the court does not have that competency to decide the case, to adjudicate the case, and therefore, if the pronouncement has been made by a court of incompetent jurisdiction, then we cannot say that the foreign judgment is conclusive. Second, not being given on the merits of the case. If the merits of the case have not been taken into consideration by the foreign courts, then also we will not term foreign judgment as conclusive. Similarly, proceedings to be founded on an incorrect view of international law or a refusal to recognize the law of India in cases in which such law is applicable. And other such conditions are when the judgment was obtained or they are opposed to natural justice or they were obtained by fraud or where it sustains a claim founded on a breach of any law in force in India which goes against our public policy. So basically, the first point says that when foreign judgment is given by a court of incompetent jurisdiction, then it will be null and void and it cannot be termed to be as conclusive. Similarly, foreign judgment, when it is not given by the foreign court based on the merits of the case, and when I say merits of the case, it essentially includes taking evidence on records, applying mind regarding the truth or falsity of the cases. Then, if the foreign court, while delivering the judgment, has not taken into consideration the case on merits, it has not been adjudicated on merits, then we cannot say that the judgment is conclusive in nature. Similarly, if foreign judgment goes against the international laws, the principles of international law or the Indian laws, then also we cannot term it as conclusive in nature. Similarly, if foreign judgment is opposed to the principles of natural justice, so we already know that there are three important principles of natural justice: rule against bias, that is, nobody can be a judge in his own case. The other one is audi ultram partem, which means that the other party has a right to be heard. And third is reasoned decision, that every decision should be backed by a proper reason. So these are the principles of natural justice. But if the foreign judgment is based on not following the principles of natural justice, then also we cannot call it conclusive in nature. As you can see, the bold part in red, impartial persons shall be there. They are supposed to act fairly and without bias. In good faith, reasonable notice shall be given to the other party, and opportunity to the other party shall be given so that they may also be heard. So, the fifth point is foreign judgment, if it has been obtained by fraud, then also we cannot term it conclusive in nature. So, which means fraud and justice never dwelt together, they cannot reside together, they are antithesis to each other. Similarly, the last point is if any foreign judgment which has been delivered by the foreign court, it was founded on breach of Indian law or if it offends our public policy, then that foreign law cannot be termed to be conclusive in nature. And same was held in the leading case of Satya versus Teja Singh. Okay, so another important topic when it comes to understand the conclusive nature of foreign judgments or the importance of foreign judgments in foreign court is section 14, which is titled as Presumption as to Foreign Judgments. So, as we have already discussed, that foreign judgments are judgments given by foreign courts. And what are foreign courts? Foreign courts are something which are situated outside India and not established or continued by the authority of the central government. So, there is this presumption which has been bestowed by law, and that too by virtue of section 14 of the Code of Civil Procedure. So, what is that presumption regarding foreign judgments? Let's read about it. It says that the court shall presume. Here, the word shall is written and not may. Okay, so the court shall presume upon the production of any document purporting to be a certified copy of a foreign judgment that such judgment was pronounced by a court of competent jurisdiction unless the contrary appears on the record, but such presumption may be displaced by proving want of jurisdiction. So, what is the value of the presumption which is attached to the foreign judgments? The section starts with the fact that the court shall presume. Every court shall presume that the foreign judgment is a genuine one. But when a certified copy, when a document which is purporting to be a certified copy of that foreign judgment has been produced before the court. Okay, but that foreign court shall be someone who was competent enough, who had the jurisdiction to decide the matter. Okay, but this thing can be questioned when there is lack of jurisdiction or want of jurisdiction. So we can say that there is this huge presumption, huge authenticity which has been given to the foreign judgments given by the foreign courts, because the term shall is written here and not may. So a lot of value has been given to the foreign judgments and to the presumption attached to it. However, it can only be exercised when a certified copy has been produced before the court, and the court which has pronounced that judgment should be competent enough, should be capable enough to exercise the jurisdiction. So, this was our today's lecture dealing with section 13 and 14, though it may be brief in nature, but it is very important to understand the foreign judgments, the value or the presumptions that are attached to the foreign judgment by virtue of section 14, and what are those circumstances in which we cannot term those foreign judgments to be conclusive. So revise section 13 and 14 of the Code of Civil Procedure to get a better understanding of the topic. With these words, Jai Hind, Jai Bharat.